welcome everyone. For those who don't know me, I'm Todd Hefner. I'm the treasurer of the Georgia Bar Construction Section, and part of the construction group with Smith Gambrell. I'm going to try and do as little talking as possible during the next hour, and that's because we're really excited to welcome 4 incredible construction mediators from across the country who have graciously agreed to join us today. If I were to list our panelists' many accomplishments and accolades, we would hardly have any time for what we are all here for, so I'm going to keep the introductions as brief as possible. I will mention, however, that all of our panelists are members of the American College of Construction Lawyers, and if you know anything about their membership, you will know that these lawyers already had a list of accolades a mile long before they were inducted into such a prestigious organization. Deborah Bellotti, who I'll start with, is a mediator and arbitrator from San Francisco, where she was in private practice for just over 40 years. She has been a full-time neutral for the past 7 years, and despite us being on opposite coasts, I've had the good fortune of having her as both a mediator and arbitrator. Steve Nelson is the Senior Director of ADR Services with Markle and is based in Dallas, Texas, and has been mediating since 1982. Prior to his starting with Markle Surety in 2001, Steve was in private practice for approximately 20 years. In a relatively recent change, he is no longer has any claims duties and is instead focused solely on mediating construction and surety disputes, something he has done over 2,000 times. We believe that's a rough estimate. Leslie King O'Neill is a mediator and arbitrator from Orlando, Florida, and has focused her career on construction law with almost 30 years in private practice and another 15 years with Brassfield and Gorey. Leslie has spent the past 3 years focused on serving as a mediator and arbitrator. Leslie also writes extensively on the intersection of construction and ADR at theconstructionadrtoolbox.com, something you should follow on LinkedIn or however you get your blog content already. And then last but not least is a mediator who probably needs no introduction to this audience, and that's Hal Gray. He is a mediator and arbitrator here in Atlanta, Georgia, who has been in private practice for just over 45 years. He has spent much of that time serving as a neutral and has conducted more mediations than he would care to count. Thank you to our panelists for joining me, and we've already got 108 people logged on, so I think I speak for all of them when I say we're excited to have you. For today's program, I kind of plan to walk through the various phases of a mediation and ask our panelists to discuss what can help get a case settled and what can hurt those chances at each step along the way. We'll probably also take some detours as we proceed, and I'll plan to do my best to leave time at the end for audience Q&A. That said, feel free to use the Q&A feature with Zoom as we go, and I'll monitor that for questions and try and work in whatever I can. First way to get to a mediation is sometimes mediation clauses, but there has to be some sort of agreement to mediate in the form of a court order, contractual mediation clause, or mutual agreement of the parties. And Leslie, I'll start with you. But what are some of the ways in which parties even get to mediation in the first place that is either going to set them up for failure or success, in your opinion?
Thanks, Todd. It's really a pleasure to be here with this esteemed group of mediators, colleagues whom I've known for many years, and this group from the Georgia Construction ADR group. So I've always been a proponent and a fan of early mediation. When I was in private practice, I tried to get cases to early mediation, and I was often disappointed that they were not very successful. And I think there has been a trend toward putting mediation clauses into construction contracts as a condition precedent for filing arbitration or litigation, which it seems like it would work, but sometimes it doesn't. And I think partly because there's usually no requirement for the parties to exchange any kind of information before that mediation takes place. And it's before the lawsuit or arbitration demand has been filed, before there's been any discovery. And the parties are kind of wedded to their positions and haven't heard anything that would challenge those positions. So my feeling about mediation clauses in contracts is that it may be helpful if they're in part of a step negotiation process that also became popular, I don't know, in the 2000s, where executives of the companies involved in the dispute would meet to try to work things out. And then if that didn't resolve the dispute, then they would go to mediation. I think having more discussion among people who are not intimately involved in the dispute is helpful. But I would add that there should be some meaningful exchange of information, such as damages calculations or expert reports. Also, an impediment in these kinds of mediations is that sometimes there needs to be litigation or arbitration filed to trigger insurance coverage. And also you have to notify the insurer of the claim and give the adjusters time to investigate and document their files. And if you're looking for insurance money to fund your settlement, if you haven't done that, it's not going to be successful. So I'm a fan of it, but it has to, I think, go hand in hand with document and information exchange.
Steve or Deborah, anything to add to that?
No, I mean, I completely agree with Leslie that early mediation is a great idea, but that doesn't mean that you can do it without having some background information. I think mediations most often fail because the people the parties don't know enough. So you've got to build into the process of getting to mediation something that allows everybody to have enough predicate information that it will be useful.
So this is something that there's a prospect or a form of mediation that has the name guided choice. And guided choice actually involves having the mediator involved early to facilitate the information exchange before the parties go to the actual negotiation table. And all of this then is done under the umbrella of the mediation and confidentiality, and so gives people a little more flexibility perhaps to share things. And I think Steve may have some comments on this.
Yeah, and I'll say this, that I get a lot of phone calls from paralegals, legal assistants, young associates that are told, call Leslie, call Steve, get a date, put it on the calendar. And they reach me sometimes surprised to find me, and I go, well, what's it about? Is everybody ready? And do they want to do it in person? Do they want to do it virtually? Do they want to, are they prepared? And I get no answers because all they were told to do is go get a date. So if anything, I'd encourage those who want to do mediations early to think about getting more information to the mediator, what you're trying to accomplish. And then we'll often then call back and say, okay, let's talk about this. Your assistant said you wanted 2 consecutive days in person in Guatemala, blah, blah, blah. And why are we going there? And why 2 days? And can't we do this virtually? What needs to be done to make it successful? And I think that's become the norm for just about everything. And we need to think about what we're doing before we just set a date.
Yeah, also, one of the things I think is a problem with having mediation as a condition precedent to filing litigation or arbitration is that sometimes counsel just looks at it as a check the box.
Right.
We've got to schedule a mediation, we're going to go do that, then we're going to go do what we're going to do. And without really thinking that we're actually going to try to settle the case at this mediation. We're just going to say, yeah, we went to Steve Nelson and he couldn't settle the case, so now we're going to arbitration. But they didn't really, as Steve pointed out, give thought to what's involved. What are the parties' positions? What is the status of the dispute? And trying to make it realistic for parties to make informed decisions about settlement. And so I'm not in favor of the check the box approach to mediation, but I am in favor of early mediation when possible, when parties have enough to make informed decisions.
And I think I agree with everything everybody said, but I also think that we need to make sure that everybody's expectations are checked. The less information we have, we may not be able to get it settled, but we may be able to make progress on getting it on the road to being settled. And that in and of itself is a pretty significant step.
True.
It's a very good point.
I mean, many cases have more than one mediation. I know that
These,
many of the cases I had as a lawyer had 2 or even 3 mediations before we finally settled the case. And even then, sometimes we didn't settle everything, but we got rid of, the easiest parts of it.
Yeah, I think that's right. You can always chip away at it. And I think one of the things that I try to tell people in that first meet and greet session is this may not be your only chance to settle this case, but it's by far the best chance you've had to this point. But you may have another one a month from now, 2 months from now, 3 months from now, 6 months from now, just as long as the process takes.
Yeah, I think it's important that people understand that it's a process. And one of the problems I see with having these early mediations without information is that the parties go to a session, they don't settle, they find the whole process unsatisfactory. And so then when someone suggests another mediation later on, they may be reluctant. They may say, well, we went to mediation, it didn't work, so why bother? You kind of poison the well. So I think it's important, like you said, Hal, to generate that expectation that this is not the only chance you may have.
So I want to turn to mediator selection at this point. Besides just selecting one of the 4 of you, and that being a good idea, what are some things that parties should take into consideration when selecting a mediator for a particular dispute? Have you ever gotten into a dispute, say, and said, I am the completely wrong mediator for this? Or and so, Jeffrey, I'll start with you on this topic.
Yeah, I really think that there are times, it hasn't happened very often, but there have been times over the last however many years where either as a litigant, as an advocate in a mediation, or as a mediator, I said to myself, what is this mediator, whether it was me or somebody else, doing in this particular case? Because not the right person for the case. I think it's really important for the lawyers to think through the parties and their personalities and the issues in the case. Look, obviously you want someone who has credibility. And I don't just mean that people will trust that he or she will not reveal confidential information and will keep the things that the parties don't want in delivered into the other room, delivered there. But credibility, both in terms of expertise and then qualities in the mediator that are going to resonate with your client or with the lawyers or with the other client. And the lawyers are uniquely suited to know what's going to make their own client unhappy, who's most likely to be persuasive to their own client, who's most likely to be persuasive to the other side. I think you want to try to figure out, is the mediator somebody who's patient? Do you want somebody who's patient? Do you want somebody who has multiple speeds or is just a kind of calm, steady influence? Do you want somebody who's going to come out of the box, in the middle of the morning saying, look, I've been through these cases a million times and I know how this is going to turn out, so let's just get to it? Or do you want somebody who holds back and says, this is the time for everybody to be able to express their views? I do a lot of talking to folks about the traditional mediations of 25, 35, 40 years ago, God forbid, where really it was, you had decision makers in the room, most of whom hadn't had much, if anything, to do with the project. That was the theory of mediation originally. And in those cases, I think it was important to have a mediator who would be very patient in moving the parties through things, because you wanted both sides to hear everything, or the decision makers to hear everything from the beginning. So I really say to the lawyers when I have my first, if they've brought me in as the mediator, when I have my pre-mediation calls with them or Zoom sessions with them, with just the lawyers separately for each party, I say, tell me what you need in me, from me, to make this successful. And more importantly, tell me what I can avoid doing to make things worse than they are when I walked in the room or when I walked onto the Zoom session. So looking for the personality and the approach to things that you want from the mediator, being sure that the mediator has sufficient credibility, and by that I mean expertise, such that if you get to the point where the party turns to the mediator and says, look, I'm going to win this. My lawyer tells me I'm going to win this. And they cheated me on the job and they didn't do this and they didn't do that. Sometimes the mediator is going to be called upon or given the avenue to say, let me tell you how I've seen this turn out 25 times before when I was, in the shoes your lawyer's in right now. You may be right. You may win this, but let me tell you what a jury's going to do. Let me tell you the kinds of things the jury's going to look at. If you don't have, I think that expertise is perhaps less important in other kinds of cases, but I think it's really crucial in construction cases. Can a mediator who hasn't handled construction cases successfully settle a construction case? Probably, occasionally. I mean, I'd be interested what my other panelists think. But I think there is usually so much in construction cases that requires a mediator with some level of credibility because they've done it themselves. So those are generally the kinds of things I look for. And I urge lawyers to really do due diligence. Even if you've heard the name of the mediator or somebody, you look up the listings in Chambers or the listings here or the listings there, and it says, oh, this person's at the top of their game and blah, 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 blah. You need to understand what you're getting to have the process be as successful as it can be. And finally, it hasn't happened much over the course of my career, either practicing as a lawyer or now as a neutral. But I remember when I was a practicing lawyer, I actually interviewed a mediator once before we retained that mediator because I had heard of them. I had heard some good things. I had heard some bad things or less favorable things. And I called up and said, can I talk to you? We're trying to decide who we're going to use. Can I talk to you for 15 minutes on the phone and ask some questions? And similarly, at least once in the last 7 years, I've had parties reach out and say, we're considering you. We'd like to talk to you before we make a decision. Is that okay? Absolutely okay. And indeed, I think it's a good idea.
I think that's all. That's great, Devin. I think you're exactly right. But I also think the mediator needs to know his or her own limitations. For example, I had a CD case where a lady got hurt in Savannah. We did a defense-only mediation in Atlanta to raise up the money put in the pot. There was no way that an Atlanta lawyer like me was going to go to Savannah and try to mediate that case with a Savannah lawyer and a Savannah plaintiff who had no fault in anything, and against a bunch of Atlanta lawyers. I mean, I've been to Savannah enough. I know what they think of Atlanta lawyers. They don't ever want to see one ever again. And I told the guys who were representing the defendants, they said, what do you do next? Let's go ahead. Let's go down to Savannah. You can come down to Savannah. I said, there's no way I'm going to Savannah.
Very good point.
Y'all go down there and get a Savannah mediator. You've got a Savannah plaintiff's lawyer. You've got a Savannah plaintiffs, and y'all figure out how much money you need to settle this case, and then come back and we'll talk about it. And we did it. It worked. I mean, I just wouldn't have had any credibility down there.
Well, and we all know as lawyers that there were places you didn't want to go out of your state in particular, because you just knew you were going to get hometown, or even if you didn't get hometown in the worst way, the perception of you when it came out that you were from X, Y, or Z place. I mean, I'm from San Francisco, California. That's a happy thing for a lot of people and a not so happy thing for a lot of other people. So it carries, Hal, I think you're quite right. It carries over into the role of the mediator, because so much of why we're successful is that people are willing at some point in the process to rely on us.
Steve, what are your thoughts on that? I mean, you travel all over hell and half of Georgia.
Well, I don't travel that much anymore. People use Zoom, but I think that is one of those things that has also opened up opportunities, not only for mediators, but for parties to pick the right mediator, even if they're not local. Sometimes when local is not the big issue, maybe Savannah and Atlanta is an issue I didn't know anything about, but now do. But you occasionally going to want to go find someone that's good at construction defects. And if they're not good, you don't have anybody locally, then it's awfully easy to get someone without having to worry about travel, just by Zoom mediation. The other is I think you want to get someone who your opponent trusts. So I often, as an advocate, let the other side pick the mediator within reason. One of the issues I run into a lot is I have been in the surety business for 25 years, and people have strong opinions whether I should mediate a surety case. Some think, well, he's going to be totally one-sided in favor of sureties. I think you'd be surprised at this stage in my career. I'm probably more critical of claims handling by sureties than most of the people in the business. You just never quite know where people stand on some issues.
Yeah, I think sometimes too, if it's a particularly heated local issue, sometimes they want someone who's not from around here.
Point.
Just for that reason. They're not connected to anybody. And so they don't, nobody says, oh, well, they're favoring this party over that party or whatever. And perhaps, like with your surety experience, Steve, they want really the subject matter expertise in particular.
Want to shift to mediation statements. And the way I'll always start things off with you, Hal, is what's something you've seen that made a mediation statement really successful, or what's something you've seen that set up the mediation for at least a much tougher mediation, if not big failure?
Sure. Well, the first thing is obviously getting it to the mediator before 9:30 the night before the mediation.
Correct.
Yes.
I mean, Steve, how many times have you walk into a mediation, somebody first said, did you get my mediation statement? Well, no. When did you send it? 11:30 last night. I tell people try to get it to me, 5 to 7 days ahead of time, which means they'll get it to me about 3 days ahead of time. But at least 3 days, it gives you enough of a chance to get through it so that you have some meaningful understanding of what's in it. The other hot button for me, and I suspect for my fellow mediators, is I don't want a summary judgment brief. I don't want an explanation of why you think you're going to shellac them and you're never going to get to a jury, or the arbitrators are going to throw it out in dispositive motion, and you go back and start citing, Hadley against Baxendale. That's not the point. The point is and I see this in arbitrations too, when you have lawyers who don't think about what it is that the arbitrator needs to make a decision. It's the same thing with this. Think about what the mediator needs to know to be able to try to successfully mediate a case. And, it's not a history of the common law in Georgia, and it's not every contract case, or if it's a CD case, every tort case ever published. We get it. I mean, you wouldn't be talking to us if we didn't get it. So, get us. If you're going to get us stuff, get us the issues, get us the parties. If the contracts are involved, get us the contracts, but don't attach a 300-page 101, 201 to the back of the statement. If there are that much expert reports, just tell us what the experts have to say. Give us the summaries, if that's even relevant. Let us know where you are in discovery. Let us know what's been done, what has to be done. If it's a CD case, let us know about insurance. Let us know about coverage. Let us know about deductibles and SIRs. Let us know if there's a DJ action pending, or if the carrier's whining about filing a DJ action. let us know if there have been any offers or demands to this point and what they were. And, you know, and I just as a personal matter, I want to know who the arbitrator is, and I want to know when the penalty case has been set to be arbitrated, because I know all the arbitrators in the Southeast. So that's the kind of information. It's not you're showing us how smart you are and how loaded your case is, and that you're going to knock it out long before you ever get to a hearing or a trial. But I think if you take the time, I counted, there's 60 people on this thing that I've mediated or arbitrated for, 60 or 65. So y'all have already heard this, but some of you listened to it, and some of you didn't. But you know, it's about thinking about what the mediator needs, and not what you want him to know about how smart you are in your summary judgment case. And the question of exchanging statements. Now, you know, in the old days, which was, I don't know, 5 years ago, maybe, you know, we always had these opening statements at the beginning of the mediation process. And for the next 2 hours, the mediators had to pull people off the ceiling to get them back down to where they were before those opening statements were given. So we've blown an hour or an hour and a half of the process just to calm people down so they can see and think again. So one of the things I think, you know, people ask me all the time, should we exchange these mediation statements? Or do you just want them confidential or what? Well, I think if they're done right, and if you think about it before you sit down to do it, it can effectively take the place telling the other side what the case is about, telling the mediator what the mediation is about, without launching people into a low trajectory orbit. And so I ask people, think about it. I'm not going to tell you to do it, but think about it. Hal Gray on mediation statements.
I've got a couple of thoughts on that. If you want a couple other comments. One is, leave off your proprietary SharePoint 3 terabyte data dump, because most of them get caught in my spam folder or don't get through to me at all. But getting the position statements early enough that we can read them and see that the parties at least are talking about the same case is helpful. I think in the last year or so, I have been the one that suggested canceling or rescheduling mediations more than I ever have before, because people have shown up less prepared, less understanding of the other side's position. And I think there is something to mediation fatigue, and that is having a mediation that just goes nowhere because neither side knew what the other was talking about. And I like to avoid those. I mean, I think if we're headed for those, I say let's get better educated and start over. Sort of a combination of opening statement and position statement, something I've seen and really advocate lately. For those who really believe that their personal presence, their experts, presentation will be helpful, but don't want to take the time on the day of mediation to do it, don't want to excite people the day of mediation, and maybe even want to give the other side time to digest what they've said, do something that we wouldn't have thought about 3 or 4 years ago before COVID. It would have taken a videographer, but sit down, turn on Zoom with your team, with your parties, your expert, pretend that the other side is on the Zoom with you, and make your pitch. 15 minutes, 20 minutes max. Push the record button, send it to the mediator to send out to everyone, or send it directly. They're more likely going to look like it. They're going to look at all of it. They're going to spread it around to more people that are in the decision-making process, who then will actually attend the mediation. And it might be more effective than that 10-page advocacy piece that you sometimes send out. Because we really don't do as many opening presentations anymore. And sometimes we do need to educate each other.
Todd, I also want to reinforce what Hal said and what Steve said in a somewhat different way. I really use the mediation statements as a way to state the obvious, get ready for the day, but I use them in another way. And that's why I'm pretty hard on people who don't give them to me at least 5 days before. I think I've only not done it in one case in the last 7 years, and I couldn't because of the timing of the statements. But I want to have pre-calls with the lawyers separately for each side after I've read their mediation statement. They don't have to be long, they don't have to be involved, but I want to ask them 4 or 5 questions, 3 stock questions. What do I need to know that's not in your statement? What are the personality issues that are problematic either between lawyers or parties? And what should I avoid? But the other benefit is that I read the mediation statements, everybody on this screen does, as soon as we get them. And if I see, as Steve just alluded to, that people are ships passing in the night, they're not even talking about the same case, or there's something that one party is fixated on in their statement that the other party hasn't even addressed, I get on the phone with the lawyers and I say, you've got time in the next 5 days to fill this hole, to get ready to fill this hole. So let's do it. Because if we get there on the day and those things are just surfacing on the day or the night before, as Hal said, you're reading the mediation statement at 10 o'clock at night because you just got it. You've wasted some really valuable time that could have been spent getting yourselves in even a better situation to mediate. And the final thing that I do is after I've gotten the statements and after I've had those calls, the day before, and I tell the lawyers I'm going to do this, as long as I've got the time, and it doesn't take much time, it means that I've read the statements and I've been able to have short calls. In those short calls, I've addressed, do we need opening presentations? Does one side need them? Do both sides need them? What should we do? Sometimes the client needs to hear their lawyer talk, or sometimes the client needs to talk directly to the other side. But what I do after I've had those calls is I send out a joint email to counsel and I say, okay, thanks for your great briefs. Thanks for the great calls. Here's how we're going to proceed on tomorrow. No joint session except to do the mediation niceties, the protocols. Then we're going to go into separate caucuses, or we're going to have short presentation, whatever, so that both sides are hearing that. And then I end with, and each of you should look for a separate email from me, because I'm going to tell you what I'm going to talk to you about in my first separate caucus with you. I used to hate the first separate caucus where the mediator came into the room and said to me in front of my client, well, I've been thinking about this and here's something we ought to address. What's the, it's better if the lawyers can know ahead of time where you're going to go with them in the first separate caucus. And you can't really do that unless you've seen their statements and been greatly benefited by a separate call with the mediator. But that's why I'm pretty firm, and I'm bugging my case manager and she's bugging the parties about getting the mediation statements in. Because if you get them to me even the day before is not really enough time. 2 or 3 days before I can live with. But I think it's really been more valuable for me to have those pre-calls and then to let the lawyers know what I'm going to do in the first separate caucuses with each side.
So I just have a couple follow-up comments. I agree with everything that everyone else said, but I think 2 things. One is that damages is something that needs to be addressed in the mediation statement, and I would highly recommend summaries. I think summaries are the best approach to these complicated cases. And it's striking to me in pre-mediation calls or even at mediations that I've had recently where I've asked people what I consider to be very basic questions, such as how much have you billed on this job? And how much have you been paid on this job? And not getting an answer. If you don't know some basic things about your case, then you probably aren't ready to mediate. Similarly, if you don't know what you're looking for, if you don't know what your damages are and how you calculated them, it's going to be very hard for the mediator to convince the other side that they should pay them. So you're helping the mediator. And I think that really is the ultimate goal in the mediation statement, is to help the mediator help you in negotiating the best possible settlement for your client. And I had one anecdote, like Debbie said, about a case I had where I gave the mediator my opening statement, my mediation statement, and the mediator came back and said, well, you don't really need to talk about this because they're not really arguing about that. What you need to talk about is this that you're not mentioning, but that's the thing they're really hung up on. And so that saved a tremendous amount of time, because, don't argue about stuff that's not in contention. Spend your money and your time on stuff that isn't in contention.
Thank you for that. We have an interesting question in the chat. Has anyone ever experienced an issue where one of the parties was insisting on no ex parte communications with the mediator?
No,
No,
never.
Okay.
Why?
Sort of a gross lack of.
I think a misguided sense of what mediation should be would be the why. But
yeah, this is James Artzer. I posed that question, and that's for an ongoing matter that I have, and it struck me as incredibly unusual, and I just wanted to pose that question to this group.
Yeah, never had it.
crazy.
Never seen it, James.
all right. Well, it seems based on some of your prior comments and the growing trends that opening sessions are generally disfavored. So I'll pose the question this way and start with you, Hal. What is a scenario in which you've actually seen an opening session be helpful?
I still believe in opening sessions, not without the opening statements by lawyers.
Okay. Yeah, and sorry, let me clarify then. I'm referring to opening statements. I generally expect there to be at least some set joint session, maybe 5-10 minutes, just to do introductions.
And I think that meet and greet is very valuable. I think it's valuable because it gives, if you are an observant mediator, you will get to see everybody in one room looking at each other. And you'll see who's bouncing a pencil, and you'll see who's not looking people in the eye, and you see who's people who's not paying attention. And it helps you sort of get the feel of the dynamic of whatever may be in that mediation. Also, it gives you a chance to explain what mediation is directly to the clients, because sometimes I'm convinced that the lawyers have said, oh yeah, we'll go down to Hal's office and we'll be in one room and they'll be in the other room, and he'll go back and forth and he'll tell us how to settle his case. Well, there's a little bit more to it than that. And I have learned that if it's the first time the clients hear about the mediation process is from the mediator, it doesn't stick as well as it was if that's the second time they've heard. So I think that's significant for it. The other thing I think it does is, and I apologize to the 60-something people who were on this, because you've all heard this before from me. It gives me a chance to tell both parties at the same time that the cheapest part about this exercise is paying lawyers, and the most expensive part is the time and opportunity cost that you're going to be involved in it. And I will go around every lawyer in that room and I'll say, tell me I'm wrong, and they won't. And it gives you a chance to sort of flesh out to the parties at one time what this process is about and what it's going to take and what's going to be involved in it. And also say, and this is a chance. It may not be the only chance, but this is a chance to get rid of that bowling ball that's in your stomach every morning when you wake up at 4 o'clock. This will give you a chance to work through some of this stuff and just try to settle this. And that's what we're going to try to do today. And the last thing I say is this is not the Emerald City. I'm not the Wizard of Oz. And you're going to have to work. You're going to have to work just as hard as everybody else is going to have to work to try to get this case settled. And that's going to involve looking at yourself, looking at your own case, and making decisions about where you want to go with this going forward. So
Todd,
I know everybody from Atlanta knows the Wizard of Oz thing.
Todd, I think the other times that I've seen true opening presentations be effective is when you have a sense, and the lawyers have shared with you, that the president of the company needs to have the other side hear directly from him or her what this case meant to them and what the project going awry meant to them or whatever. It sounds a little touchy-feely, but I do think sometimes I've gotten to the middle of a day where we didn't have substantive opening presentations, and I realize that one party in the room, there might be 15 parties, but one of them needs to be heard, right? And that the fact that we didn't have the opening presentations, substantive presentations, they're still mired in nobody's hearing me. And it's, as I said, it sounds like we're talking about, a divorce case or an employment case. We're not. I've been amazed. I was amazed when I was a practicing lawyer in construction, and I continue to be amazed by people who think that emotions, it's just business. It's not just business. It's these people's business. It's their staff's business. So when you get a sense that the way to move this case to resolution is going to be that party A's mid-level manager, senior person, whatever, feels like they have finally been heard, and the mediator can then say, Mr. So-and-so, I understand. It didn't jump off the page at me what this case really meant to your business. I understand it now. Sometimes just that is enough to shift the balance and to move the case forward to a better resolution or a quicker resolution.
I think.
Go ahead, Leslie.
I was going to say, I think particularly when you have these large multi-party cases, you may have more parties who have not really experienced disputes or mediation, and they think this is going to be their quote day in court, and
Right.
they expect to be able to tell their story, and if they don't, then they're not ever going to be satisfied with the outcome.
Right.
And so I think that's part of what you find out, hopefully, in those early pre-mediation calls, is sort of what is the experience level of the folks in this company. I mean, the company may have been in business 50 years, but maybe this is the first time they've ever been sued.
One of Steve Nelson's great ideas, and he has a bunch of them, and I've stolen all of them I can, is the back room conversations. Open up the back rooms, rooms, and let people go in and out of them as they want to, with the caveat that you can't go somewhere you're not invited. And that opens up the opportunity to have business people go talk to business people. And it takes it out of the traditional structure of one side's in one room, the other side's in the other room. I think it's a great idea, Steve, and I have stolen it, and I think it works. Maybe why don't you explain it a little bit?
Well, he's talking about obviously virtual, where normally one of the things that we miss is that opportunity where a couple of lawyers meet at the coffee bar and solve a problem that while the mediator is doing something else. And we miss that. So I will give co-host privileges, which is the way on Zoom people are able to move themselves around, to anybody that wants it. And I'll create extra rooms. I'll call it the coffee bar, the men's room, whatever I got to call it, where they're going to run into each other, so that lawyers or parties can say, I'm going to go while Steve's off talking to so-and-so, I'm going to see if I can't get in a room with the executive of the other company.
Right.
I think initially we were all afraid, well, everybody's going to bust into the wrong room and they're going to go, people were concerned, people that had extra privileges to move around could listen to them or something. I've never had a problem with that. The Chinese are probably listening, but nothing else has changed.
Well, the other thing it does is, Steve, I haven't used it yet either, but it's a brilliant idea when I saw it in your article. That's part of the materials for this program. The other thing that it does is it avoids the mediator having to figure out a kind of covert way to get one of the lawyers into a room with the mediator alone because the client's being a jerk and you know it, and or the adjuster is being a jerk, or pick your jerk. And I have to figure out do I send a text to the lawyer saying, can I put you in the neutral room with me? If you have a little more flexibility on people being able to move around, you avoid that. I mean, it just becomes a natural flow of things, which is good. So
Which is an issue. Lawyers love to have their clients show up in their office, sit around the conference table with them on a virtual mediation. It helps with the collaboration. They get to spend time together. They get to talk about what's going on. But it then becomes difficult for me to pull the lawyer out without being very obvious. So
terrible.
When I know it's likely to be a problem, I suggest the lawyer have a Zoom call set up in another room so that if I text them or ask them to come meet me someplace, that we can talk separately. And that's one of the things. If it was in person, you didn't have a problem. You just stuck your head in and say, come out here, I got a lawyer meeting. And nobody thought too much about it. But it gets a little more obvious when you have to say, could you have all your clients leave the room?
Yeah, right.
It doesn't work.
Or God forbid, can I get rid of that? Could you just send Harry?
Send the adjuster away.
Just send him away. I want to talk to all the rest of you. It avoids that.
The next topic I wanted to cover, at least briefly, is just as the mediation is going on throughout the day, how do you, or maybe what factors are more important in your decision on which party to start with and how much time to spend with each party and how to go back and forth? If there are any strategies or if it's all by feel. So, Deborah, I'll start with you on that one.
I decide really based on the party that I think I need the most additional information from, or the nuance piece that I feel like I don't have, and I need to get them thinking about it sooner rather than later, and I know it's going to take some time. I'm usually inclined to go to that party first, and sometimes I'm relatively transparent about why I'm going to one party or the other. Sometimes I will say there's no real magic to this, but I might say, because the claimant has a claim, I want to start with the claimant. That may not be the reason I'm doing it or may not be the only reason I'm doing it, but I think it is so case specific. It's where I think perhaps more work needs to be done, or there's something I think that party hasn't come to grips with yet. So I want to talk through with them that point so that they can spend some time when I go talk to the other party, thinking about that and chewing on that and maybe talking to their expert offline or whatever. That's just how I approach it.
All right. With no one else jumping in, I'll switch topics. Steve, this one I'll throw to you first, and this is multi-party mediations. I don't know if you're aware or not, but you actually have a reputation in Atlanta as being a great multi-party mediator. And I'm wondering if you can share with everyone your secrets or not. But just wanted to cue you up on multi-party mediations.
I don't know that I have any secrets. I enjoy the multi-party mediations. You give me 20 parties, I like that better than 2 parties any day of the week. With 20 parties, if I got somebody that's, being a problem, hadn't figured out what they want to do, I can go talk to 19 others until they kind of come around. But there's some things that make that process work better. First of all, it is a process. It's not an event. You cannot just put a date on the calendar and say 20 parties are going to show up and we're going to try to settle something. It requires some pre-meetings, certainly with the major players, often with the smallest player who just has got to, on the day of mediation, we got 20 parties, got 80 people in the Zoom conference. And the one party says, we're just a small player. We'd like to get out. Could you visit with us first? And then they want to give me a 45-minute PowerPoint about the flashing that they didn't do wrong. You got to think about mediation day is likely me with the spreadsheet trying to get checks and deposit slips to add up to a number that settles the case. And the venting and the pre-process, pre-mediation discussions that need to have taken place long before that. Another thing I have pretty much do as a standard is make it all double blind. I was on a large law firm's compensation committee for years where we would give a recommendation that, Leslie, this year you're going to make $300,000. And Leslie would go, oh God, that's great. That's wonderful. That's a big raise. Thank you very much. Y'all are so smart. And then we'd tell Hal, you're going to make $305,000. And Hal would say, that's great. Oh, that's wonderful. And then we unveiled all the numbers and Hal would come to me and say, I can't believe you gave her 300 and only me 305. I'm now very unhappy. It's the theory of relativity, I call it. And so you've got you'll have the adjuster that says, I'll give you 50 grand, but I'll tell you what, they've got to match it, or I don't want to pay anything less than or 1/3 or more than 1/3 of what someone else is paying. Pretty soon I have this double quadratic equation that I can't even keep track of that people want me to adhere to. And I say, no, everybody's going to tell me their numbers. I'm not going to tell anybody else. Subcontractors, I'm not going to tell the general contractor what you're contributing. I will keep it quiet. We'll settle this case and eventually settle it in escrow. The checks come to me and I write one check and nobody will ever know. So you can all say that you won. You all say you got the best deal of anybody there. And if it's a number that satisfies your interests, stop worrying about what the guy or gal next to you paid or got. And, I get some folks that balk at that at times, but after a while they become believers. And then obviously if people use it to hide, eventually you have to go back to disclose numbers because they're trying to hide and not put any money into the pot. But I've never had much of a problem with that. You start getting lots of parties. I'm a big advocate of co-mediators, even if they're junior assistants that can run messages back and forth to the rooms to keep people happy. Idle lawyers are the devil's workshop. And you end up with, 6, 8, 10 lawyers that have been sitting around since lunchtime. And the last time they saw me was at 9 o'clock in the morning. They start getting very frustrated, and worse yet, they start thinking harder about their case and deciding it's better than it was when they came in that morning. So I like to have something that keeps everybody engaged all day, and having someone else working on it, I think is very helpful. And then one other thing I think that I have used a lot more lately in the big construction defect cases, the multi-party cases, is I'm big on recommending neutral evaluators. Lately, there's so many of these cases where the plaintiff has got a damage model and a dollar amount for that scope of work, and the defendants collectively have one that's dramatically different. And I don't blame anybody for not wanting to spend more than what their expert said is the damage, but their expert might be wrong. And so sometimes It just takes a neutral to come in and say, let's get a new data point for both of you to consider, non-binding. And I've been doing that a lot more lately. But it's definitely a process, not an event.
That's for sure.
Well, let me switch to a couple lightning round questions and go around the horn on these. What is the most obscure location you've ever conducted a mediation? Hal, I'll start with you.
I default to Steve. I'll default on behalf of everybody else up here. But because the craziest place we have ever been will probably be one of the tamest places Steve Nelson's has ever been.
All right, Steve. So what's the answer then?
And I don't know, somebody on here may have actually been in this mediation, but it was in the vault at where we keep all of the nuclear fissionable material in North America in Oak Ridge, Tennessee.
Oh my God.
Where the mediation was conducted. And as I would leave a room, my notes had to be sealed in a case. And I had 2 Marine guards with guns, M16s, that would carry the briefcase to the next room.
Oh my God.
It was really kind of surreal, and it settled. But and there was no reason in the world to have it in that location, other than they were trying to impress me as being one of the few human beings around who had ever been inside the place. And by the way, I was thinking it was going to be really cool, strobe lights and stainless steel. It looks just like a Home Depot with a bunch of Tennessee hillbillies on forklifts running around. Billy Joe, that warhead on aisle 7 is leaking. Y'all need to get that cleaned up. So it was very disappointing.
Proving that Hal was right. Yes, I can't even get close.
Yeah.
Well,
That's a throw in.
here's one I wouldn't mind. Another kind of lightning round is what's one book or other resource you found helpful as part of your mediation practice? Leslie, I'll start with you.
So I really like Bargaining with the Devil, which is a book by Robert Mnookin. He's a professor, I think he's still there at the Harvard Negotiation Project, but he wrote this book and it's quite interesting. I think actually bargain with the devil himself, but he has some true stories about bargaining and a huge case he had, an intellectual property case in which he and another person were basically doing what's called meet-arb, which is a concept I was not particularly familiar with and thought was kind of ridiculous until I read his book and said, well, I don't think it would have settled otherwise. So it's an interesting book. It's not a hard read. It's very entertaining. So I recommend that. It's good for mediators or advocates.
Steven, looks like you grabbed something off the shelf there.
Yep. It will show up backwards though. It's called Controlling the Cost of Conflict by Carl Slaku and Ralph Hassan. It's a really good book if you're trying to guide clients through how to set up, either an internal dispute resolution process or how to think about dealing with conflict. And it makes a point that having disputes is not bad. I mean, heck, people having differences of opinion about things is what makes the world go around. The sin is not having processes in place to deal with them effectively or using the wrong tools. And I suspect all 4 of us went to law school where mediation was never taught. The only tool we came out with was litigation. And just like if the only tool you've got is a hammer, everything looks like a nail. It takes a while for some people, and all of us included, to realize there are a lot of other tools out there, whether it's mediation, dispute review boards, standing neutrals, all kinds of things like that. It's a great book. It's a great book. Get it on Amazon.
Deborah?
Well, I'm going to cheat because mine is actually not a book. Mine is actually something that I hope people can still find. When I was a very young lawyer, one of the training sessions we did in-house at my law firm, Farrell, Brown and Martell, was once a week, all the young associates would get together, and with one or two partners, we would watch the Irving Younger tapes on how to try a jury case. And I have to say, the material that came out of that has stayed with me forever. And the reason I cite it here in the context of mediation is, I think to some extent, trial lawyers forget the kind of basic stuff about how to deal with people and how to deal with people in conflict and how to pitch your position to a jury. It isn't that much different when you're mediating to kind of focus on what normal people are thinking and doing when they're in conflict. And so I would urge lawyers to see if those are still available and look at them. You know, there are lots of books, and I tend to read mysteries a lot when I have downtime. So I don't have a lot of, I probably haven't read half the books that Leslie or Steve or Hal have read. But I really think the concept of understanding what people in the real world really think and need to get to decision-making points was a very useful tool to me as a lawyer, and it's a really useful tool to me as a mediator.
And just for those wondering, a quick search, there's a lot of those videos on YouTube right now. It looks like. So, Hal, what about you?
It's the same book Steve referred to, Controlling Costs. I mean, I think it hits so many different parts of the whole thing and does it in an analytical way. It just explains a lot. It's a very well thought through, well-written book.
All right, so we are unfortunately already over time by a couple of minutes. Thank you for this amazing session. I think we could have gone for many hours, honestly, and kind of only scratched the surface on the expertise the four of you have to offer. So thank you again for taking the time to join us. Really appreciate it.